chasing what only a dream, breaks in the scheme. Waking up at dawn, all my fears are gone. I won't stop today, never, never, not today. Compromise, rise above it all, not gonna fall. Step by step I go, faster than the flow. Broke through every chain, I will not be contained.
Good evening, everybody. I hope you're having a wonderful evening. Man, oh man, have we got some new stuff for you tonight. Let's go, friends. Dan, how you doing? Long time no see. Man, you just disappeared on me for a while there. Glad to see that you're back, making it to alive. Awesome, awesome, awesome. Good to see you, Heidi. Stacy, Brenda, CJ. Good to see you, Katie Kate, King Paco, Brenda, and everybody else. If I missed anybody, oh my gosh, did you see the new little thing that you got there? Got a new emoji. Yeah, I'm glad you are. Life does get bad. Life does get bad. Well, I'm glad that you could make it back. I'm absolutely happy that you could make it back. Speaking of bad lives, gosh, what do we have? We've got motions and all kinds of crap that came in, and of course, we have the motions hearing that happened today. It's a pretty short hearing, so if we run through all of this, maybe we'll make some sweet music. Got some ideas for some stuff now. I created some. That's why I was running a little bit late. I was like, I wonder how this will work. Let's write a happy song. Everybody's so angry lately. I don't understand the anger. There we go. So there was a motion. This was filed on 9/20/2024. The motion for the court-appointed experts to produce reports. And if you see, this is written by Dave Cacciatore, Jr., the assistant state attorney. So this is the prosecutor that's sending this. It says, comes now the state of Florida by and through the undersigned assistant state attorney and requests that the court appoint clinical psychologist Dr. Michael Brannon and court-appointed crime scene reconstructionist death investigator Dr. Michael Berkland produce reports of their findings prior to trial. Yeah, that's going to be insane right there. See if we can embiggen this right here. There we go. Didn't embiggen. And then, of course, court granted the motion to appoint these doctors on September 19th, 2024. The state requested that these doctors provide written reports prior to trial. Defense objects to this request by the state. Neither Dr. Brannon nor Berkland were listed on the amended witness list in this case. The state has not previously had opportunity to depose them. The case at bar is currently set for October 7th, 2024. Therefore, the state would request that both of them provide reports regarding their findings to the state and certify that they send it out to everybody involved in this. And well, that right there, that motion would be denied. Orders motion for a court-appointed experts to produce reports. This cause having come on to be heard before being chambers on September 24th, 2024 upon the state's motion. And the court having reviewed the motion, the court file being otherwise duly advised on the premise hereby, orders and adjudices as follow. The motion is hereby denied. So you don't have a chance to depose them. Tough, kitty. Judge is moving forward. He's done playing. He's done playing. He said, nope, you ain't getting your motion. We ain't moving forward. You got nothing. And of course, then there was a motion that was filed on the 20th also. This was a different order, and this was the scheduling order for the defense of battered spouse syndrome. This was the order that came in on the 20th. Open and shut hearing for an open and shut case. Too soon? Well, no, they were under lockdown at the time. They were playing hide and seek just a little bit. Not hide the salami, because, well, if they were trying to hide the salami, well, he didn't get enough. This cause came before the court on September 19th, 2024, on the state's motion to strike defendant's notice of intent to rely on defense battered spouse syndrome. Blah, 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 blah. Just basically her complaining about battered wife syndrome. Battered spouse, whatever. This matter is set for the trial October 7th, 2024. See the court scheduling order and notice of hearing. And then it basically just tells you the filing. The defendant filed a certain notice to intent to rely on it. Notice provides a statement of particulars showing the nature of the defense battered woman syndrome as a result of physical and psychological abuse the defendant sustained at the hands of the victim, Jorge Torres, and the name and address of a witness, Dr. Julie Harper. The state filed a motion on the 6th. On the 13th, defendant filed a response. On the 15th, defendant filed certain amended notice of intent. And then the amended notice, among other things, provides the same statements of particulars showing the nature of the defense and the name and addresses of 6 witnesses. On September 19th, the state filed the amended notice motion. The court finds that both the notice and the amended notice comply with Florida criminal codes, Medina versus State. Has relied on the state all address exclusions or admissible expert testimonies on the battered spouse syndrome at trial, not pretrial exclusion or expert testimony on battered spouse syndrome. Address the introduction of the battered spouse syndrome as evidence, not the pretrial exclusion of the same. I still think Jorge was a battered spouse, not her. No, it was mutual. I think both of them were mutually just. I've known couples like this. They get very angry at one another, especially if they've been drinking. They yell, they scream, they holler, they fight, slap each other around, and if they're sober, that usually just turns into some weird sort of sex kink kind of thing. Yes, but whenever they've been drinking, sometimes people get sick of it and they call the cops, or one calls the cop on the other one. And then they turn around, they bail them out because, well, they feel like they're at fault also. So it's a combination of both. I mean, they're aggressive towards one another. Culture, I don't know what it is that causes it, but I've seen it before. And I'm no doctor. I just had, being a musician, you have lots of various roommates, and some of them like to drink, and some girlfriends like to be abused, and some guys like to be abused. It's just, everybody's got their weird kink. I don't know. I don't get it. Me, I'm just happy just chilling with my wife. We don't even really argue. Our arguments last like 5 minutes, and we're just like, okay, and then we walk away. It's weird. I know. It's pretty easy to do. As relied on by the state, all address exclusions of admissibility of expert testimony on battered spouse syndrome at trial, not pretrial exclusion of expert testimony on battered spouse syndrome review granted. Addresses the introduction of battered spouse syndrome and evidence, not the pretrial exclusion of the same. State relies heavily on Wagner v. State. According to Appellate's testimony, she bent down to pick up the keys with her left hand. The gun that she was holding in her right hand accidentally discharged, and she absolutely did not intentionally pull the trigger. She was not aiming at anything when the gun went off. It discharged, struck the husband in the lower back. Trial court precluded her from presenting the battered spouse syndrome. At the hearing, no outright evidence of an accident was presented. The motion and amended motion are granted in part and denied in part. Parts of the motion are holding, and some of them are not. Adaptive codependency. See, I'm not a doctor. I don't know these kinds. The motions and amended motion are granted in part and denied in part. Motion and amended motion are granted in that the defendant shall submit to an examination by an expert of the state's choosing. Said examination shall take place no later than day after tomorrow. The motion and amended motion are denied in that the motion notice of the amended notice shall not be strict. States request precluded defendant from mentioning battered spouse syndrome in her opening statement is denied. State's request to prevent any mention of the battered spouse syndrome until admissible evidence is of a justifiable use of deadly force is admitted into evidence at trial, and admissible evidence of battered spouse syndrome is admitted into evidence at trial is also denied. Yeah. So basically, you can't talk about it. You can't bring this up. You can't use this as a defense. Completely done, and all of it denied. I need to blow my nose. I'll be right back. Give me just a second. I'll give you a little bit of music. It won't take long. I forgot to grab a tissue. I'm all sniffly. So give me just a second. I'll play a little bit of music. How's that? I'll be right back.
Running through the maze, I felt the pain, chasing what only a dream, breaks in the scheme.
Whew. Oh, wow. That was needed. I was all snuffling. How much you want to bet that her attorney tries to slip it in the opening statement? Well, he would be smart if he didn't. That right there can get you sanctioned pretty damn quick. Judge will hold him in contempt for trying to pull that stuff. That's he's gonna try to make that defense without saying it. But there will be objections. There will be objections on that. All right, here we go. This is what came up today. Motion to suppress defendant's statement at OCSO. Comes now the defendant by and through the undersigned attorney, pursuant to Rule 319.0 subsection H, Florida Rules of Criminal Procedure in the 5th and 6th Amendments of the United States Constitution and Article Section 9 of the Florida Constitution, and respectfully moves the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof states as follows. Now, this is interesting. This is very interesting here. So they're trying to place in here to have all of her expert tests, all of her own testimony stricken from the record. Now, so all of her statements that she made in her interrogation, all of the statements she made at the first interrogation, which was at her home, I mean, you might as well just take out every single bit of all the things that she said, admitting to certain things, and just saying, yeah, that never happened. Now you've got to prove that I did it. But we have your own testimony that you did this. And that right there should be enough to have her held for quite some time. Oh no, this lawyer is trying. At least he's trying. The defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. The fact. On about the 24th, the defendant called 911 in response to finding her boyfriend, Jorge Torres Jr. no longer living. Like he ain't kicking anymore. Deputy Caleb Rodriguez of the Orange County Sheriff's Office, OCSO, arrived on scene with her body cam activated, as she would do in any other case. Deputy Rodriguez spoke to the defendant and realized the death had occurred. No shade, Sherlock. Deputy Rodriguez advised her superiors, and she started to secure the scene. Well, she did secure the scene. Well, and sometime later, homicide investigators Chelsea Connolly, a.k.a. Chelsea Lee Copskill, and Scott Lowen arrived. Now, these two investigators would ultimately be responsible for this homicide investigation. Were involved in the interrogation of the defendant at the OCSO. The defendant was ordered to remain on scene while OCSO conducted their investigation. That's not true. The defendant was conducted their investigation. The defendant stayed outside of her apartment for approximately 14 hours during this time. Not bloody likely. Not bloody likely. What is that? How much you want better returns? Oh, yeah, I already read that. Not bloody likely. Yeah. During this time, of course, they would not let her back in because it's a crime scene. At some point, the defendant was asked to get into a vehicle with Detective Copesel and Detective Lowen. Once inside, Detective Copesel recorded an interrogation with the defendant after partially reading her Miranda rights. Now, what they're saying is he omitted the final question. Now, we heard what the judge had to say about this, and he wasn't too happy with it. The judge said, listen, you're going to have to do more than prove that because the burden of proof on you for this is you. And that it just because you leave out the final portion of it does not mean anything. Because her rights are pretty straightforward. Asked her if she understood her rights. She said yes. The defendant. Because whenever you hear what the state's response is going to be to this, it's neither here nor there. He did not make a very good case whenever he started. Was advised this recorded interrogation was routine protocol and official procedure for any death investigation. During the investigation, Detective Copesel asked to see the defendant's phone. The defendant complied and gave her phone to the detective. The defendant was asked to unlock her phone, and she complied with the demands of the lead investigator. After David Copesel had the defendant's phone for a period of time, she came back and told the defendant she was taking the phone. Detective Copesel asked the defendant to sign a form releasing it to the OCSO for further investigation. There you go. That's all it takes. The defendant acquiesced to the authority and signed the form. There you go. So she gave that phone up willingly. She knew what she was getting into. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Now, imagine this. You do something horrendous that's not even involved in this crime. You do something. Maybe you're sitting there, hitting a crack pipe, or, you're, doing something vile to a child. And detective gets your phone. You don't even know that it's on there because you were drunk. And they take that phone and they open it up, and they pull the videos off of it, and they see that this horrible thing happened. Do you think they're going to return your phone to you? Probably not. They're going to call you in and start asking you some questions. Maybe those questions are not related to whatever you were there for in the first place. Here's where the crux lays out. She's going to lose this motion. Is this attorney Bubbles Brothers completely ignoring the facts? Hey, Frank Otter, how you doing? No, he's not completely ignoring the facts. He's just, this is what lawyers have to do. They have to try to get the facts to show something different. It's a long stretch because they They have all of this on video. They have her taunting him as he's in the suitcase. You have her admitting that nobody else came in or left during this period of time. So what are you going to do? Going to go for that person. The defendant acquiesced. The defendant was told that one of the detectives would return to the apartment in Winter Park. Later that evening, defendant moved to her ex-husband's home, Brian Boone. Night, using her ex-husband's phone, the defendant called the lead detective, Chelsea Copesell, to express her concern that Detective Copesell was not being truthful about law enforcement motives as it relates to the defendant. Defendant told the detective she believed that they were trying to trick her. Really? So she thinks she's being tricked. Well, that's not true. That would mean that they would have had to be trying to trick her. Now, you Trixies, you're trying to get me, Trixies. No, they are simply trying to get her to come in and admit what happened that night, or get to the bottom of it. I mean, sometimes there could be an absolute excuse for it. Maybe he did lock himself in the suitcase. Maybe somebody else locked him in the suitcase and then just dropped him off. They're walking into this situation blind, where she's already there and she knows what happened. How is that trying to trick somebody? Never know. Had to get a little something to eat. Ooh. So, the detective assured the defendant that they were not trying to trick her or implicate her, but that the following day the defendant needed to drive to the OCSCS or whatever to retrieve her phone. The detective explained the reason for the change of plans was because she was pregnant and not feeling well. Okay. Doesn't matter what the reason is. She still drove there. The detective assured the defendant they were not trying to trick her or implicate her. Next day, defendant arrived at OCSO to retrieve her phone and had questions about this tragic event. While still under the impression she was retrieving her phone, Detective Lowen led the defendant upstairs to an interrogation room. A custodial interrogation ensued. Immediately after the interrogation, the defendant was arrested and charged with the offense above. The only thing was, she was read her rights again. The approximate 2-hour interrogation was recorded, which we've watched here. The initial dialogue between Detective Copesell and the defendant, Sarah Boone. Detective, I'm going to have you sit in the green chair. I appreciate you coming in. She says, yes, ma'am, and I want to ask about these whatsoever if you have a moment, referring to her written notes with questions. Sarah, in her written notes. Detective says, sure. So obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And we're not done talking about the incident. We just have to do it. Just like we did yesterday? Normal protocol? Just like we did yesterday. Remember I read you the rights? Yeah, that's the exact same thing since I'm asking you follow-up questions. I need you to read them to you, okay? So you have the right to remain silent. Anything you say can and may be used against you in court. You have the right to talk to a lawyer before, during questioning without charge. If you cannot afford an attorney and want one can be provided for you before questioning without charge. Has anyone threatened or promised you anything to get you to talk to me? No. And do you understand what I just read to you? Yep. Perfect. Okay. So this morning we went to his autopsy and we were informed of some injuries he had by the doctor. Where? So he's got scratch marks to his back. And this interrogation continued for approximately 2. Okay. What he's asking her, what this other one was, are you under the influence? I believe is a question. But it won't matter. Because basically she's saying she wasn't influenced by anyone. In the end, while still in the interrogation room, defendant was placed in handcuffs and arrested. Detective read the defendant. Detective read the defendant her Miranda rights directly from the printed card of the OSCSO. Detective omitted the same Miranda rights question that she omitted the day before. The admitted final rights questions. Having these rights in mind, do you wish to talk to us now? Okay. Doesn't matter. It doesn't matter. Leaving one little piece out there doesn't change anything. Because that right there is just a waiver. That right there is just a warning. That's all it is. Now, if they wouldn't have told her that she had a right to an attorney, that would have been a different story. They did. Based on all the circumstances surrounding this interrogation, the defendant's statement was coerced and not freely and voluntarily given. Really? How was it coerced? She sounded like she was answering those questions pretty freely to me. As such, the entire 2-hour interrogation should be suppressed. Huh? And of course, upon information and belief, it would look something like this. Well, that's just information and belief. Doesn't mean that it's true. As such, the entire 2-hour interrogation should be suppressed. Wherefore, the defendant requests that pursuant this rule of the Florida Criminal Procedure and 5th and 6th Amendments of the United States Constitution, Article 1, Section 9 of the Florida Constitution, reduce, blah, blah, blah. So, why don't we just do this? Right? And, thanks. All right. The whole part of the Miranda rights is all of that is, and this is just according to LegalZoom, nothing in particular. The following is a standard Miranda warning. You have the right to remain silent. Anything you say can and will be used against you in court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. If you cannot afford a lawyer, one will be provided for you at government expense. Each state makes its own rules about exactly what must be said, told to suspects who have been arrested or being held for interrogation by police. But the Supreme Court decision requires these 4 points be clearly covered. Pretty cool, huh? Even an idiot like me can find this out. And do that. We'll close this. The order was that we already read that order. Close all that. Close all tabs. And we will present screen for you here. So there you go. There it is. There it is. The components of the Miranda warning. Following is the standard for Miranda warning: right to remain silent. Anything you say can and will be used against you in court of law. You have the right to speak to an attorney and to have an attorney present during any questioning. And number 4, if you cannot afford a lawyer, one will be provided for you at government expense. That's it. Those are the only 4 things that they have to have. Now, each state makes its own rules about exactly what must be told to suspects who have been arrested. But the Supreme Court's decision requires these 4 points be clearly communicated. 1, your right to being silent. Anything you say can be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. So, why don't we look and see what Florida Miranda rights are? That would be the thing to do. Is look up and see what Florida's Miranda rights are. I love doing this stuff right here. I know real quick so you don't see all my porn pages that are up. I'm kidding. I don't need those most days. All right, let's look and see what Florida. What is law on Florida Miranda rights? All right, there it is in Florida. Let's see. Miranda rights, comprehensive sites. And go ahead and bring this thing up. Yeah. Miranda 384 U.S. 436 in the ruling, the justice found the statements made by Miranda could not be used against him as evidence, blah, blah, blah. Specifically, the court held that prior to being interrogated, a suspect must be informed that they have the right to remain silent, that anything they say can will be used against them, that they have the right to consult with a lawyer, and they have a lawyer with them during the interrogation, and that if they are indigent or not able to afford one, that one would be appointed to them. All 4 points. All right. And then we can go back here to this one right here where it says Miranda rights do not apply in the following circumstances: when a person waives their rights, which she did; when a lawyer is present, which she did not; when the person is not in custody, well, they were in custody; when the person is not being questioned, she was being questioned; when the person provides a voluntary statement to the police, which she did; when law enforcement is acting undercover. So, if a lawyer, if a guy is working, a cop is working undercover, Miranda rights don't apply. So, did she follow any of the 4 points? The right to remain silent? No. Did she ask for an attorney to be present? No. If she couldn't afford an attorney, it is moot at that point because she didn't need it. Anything the person says can and will be used against them in court. And she was informed of all those rights, and she still decided to speak. The Popo. So, there you go. That's all that matters. What was that? Check out LV Cops v. Karen Reed trial ringleader cop get heard cops front yard approximately 4 days ago. TV Cops TV Karen. What that means? Karen Reed trial ringleader. Oh, okay. Karen Reed. Gotcha. 4 days ago, huh? That's interesting. We'll take a look at that. But right now, we've got interesting little video we're going to be showing you. Only about 15 minutes long. And I think that you'll find it much more enjoyable whenever it is blasting your ears out. So that's always a good thing. And we'll open that up there. And here we go. Let's do this. Oh, yeah.
Yes, thank you. Next up is 2020 CF 2603, State of Florida versus Sarah Boone. Mr. Lake, you're here on behalf of JAC.
I am, Your Honor.
All right, and Ms. Cashman, you're here on, as one of the attorneys on the case.
I am, Your Honor. I'm assuming that, like the last attorney, I will be permitted to stay seated because of the microphone issue. Thank you.
Although I do recognize you're probably like me, it's hard to argue while you're seated.
It's a very unnatural feel.
Who else is here on Ms. Boone's case?
Frank Bankiewicz on behalf of Mr. Boone. Judge, I believe I said in my notes that attorney number 7, but I think I was actually attorney number 6 on the case. I've had the case the longest of the 3 of us that are appearing before the court now.
All right, thank you. And Mr. Hobson, you were court appointed to Ms. Boone at some point during her saga as well?
Yes, Your Honor. After Mr. Bankiewicz withdrew, I was appointed.
All right. So we have all 3 of your bills, and I know JAC had indicated they had no objection to Ms. Cashman's bill, but I did not get a similar statement with regard to Mr. Bankiewicz or Mr. Hobson, so I thought I needed to have a hearing with all 3 of you present. I am,
Right.
Mr. Lake?
I was saying, there is an objection here because essentially what we're at this point is this is compensation in excess of the flat fee because there's 3 attorneys involved. So there's no line item objections per se because these are all flat fee bills, but we're basically objecting on the basis that the total compensation here is going to exceed the flat fee to some extent.
Right. And I will tell you that I am very familiar with Ms. Boone's case because she has gone through many attorneys and has, according to Judge Kranick's order, sabotaged those relationships. And accordingly, attorneys needed to withdraw and new attorneys were appointed. And I do recognize that a lot of work was done.
Yeah, she was
for
being
Ms.
really
Boone.
difficult.
So we will start with Mr. Bankiewicz, then move to Mr. Hobson.
Thank you, Your Honor. Basically, I had the case for a little over a year. I had 175 hours in the case, including actually 45 hours at the jail with the defendant. When I received the case, I got a box of crazy information, I'll put it that way. And it was an entire file box, and it took weeks to go through it, categorize it, and kind of figure out what was going in the case at that point in time. She originally had a privately retained attorney, and I basically received his case and his file because all of the other court-appointed attorneys before me, I believe, had waived any attorney's fees, and because they did basically nothing on the case. The 3 of us did a lot of work in the case. As I said, I put in 175 hours, and even at the $75 an hour compensation ratio, we're looking at $14,000. Spent a lot of time with Ms. Boone and a lot of time on the case. So I'm requesting a flat fee in this case.
All right, thank you. Mr. Hobson.
Good morning, Your Honor. Good morning, everyone. Your Honor, I got the case from Mr. Bankiewicz, and I got the same information. The information Mr. Bankiewicz has recited that he had and reviewed, and in addition, of course, his information on top of all of that. I spent some time with the defendant at the jail. I spent a tremendous amount of time with the investigator reviewing the case, talking about discovery, experts, and so forth. I spent a tremendous amount of time with a proposed expert, Dr. Linda DeRay, that it turns out the defendant didn't like her. I thought she'd be great. We talked for dozens of hours, almost daily, extensive periods of time, coming up with theory of defense or theories of defense. At the in fact, you combine the information from the expert defense attorney that was privately involved and took the case to the right up to the edge for trial, and then had to back out. So I had that information. Those boxes are box of information Mr. Bankowitz talked about. I had those. I had to go through those. I gave all that material to Ms. Cashman, plus my information on top of that. Spent a lot of time interviewing people about how they'd respond if they were jurors. So I was looking at the case from all angles. I had the case from, I believe, September 23 until May 24. I would say conservatively, any lawyer that had this case can tell you easily they spent at least an hour to 2 hours on this case every single day, given the information coming in from Ms. Boone, the matter she wanted dealt with, her theory on the law versus our theory on it. Was a constant battle going back and forth. And you had to deal with the
It's been
gaslighting.
difficult.
I told Judge Kranick at the time that I withdrew that it's just was too much. This case required at least 2 lawyers. I told that to Judge Kranick, plus possibly an assistant. I see now the case has 3 lawyers, plus experts that we worked at getting, plus investigators. So everything they're doing now,
Plus
we
investigator.
attempted to do. We made every effort to do all those things. Miss Boone now has custody of files belonging to myself, Ms. Cashman, and Mr. Bankowitz. We did just
Mine's
put in a
more.
tremendous amount of work. It taxed every fiber in your body and the bodies of the assistants or any person that worked with you on this matter. And I think flat fee for each of the attorney would be exceedingly reasonable, Judge. And I heard the judge comments regarding $75 an hour. I won't even speak to that. It would be totally redundant given the expert knowledge of all the attorneys and Your Honor involved in this case and any other case we come to the court on regarding fees. But this was a extremely difficult case, Judge. Most of the difficulty revolved around just handling the defendant
Miss Boone.
and coordinating the defendant. Thoughts on how
Well, that's not going to be
go,
uncommon. You're
what
going
our
to have to
experts
deal
were
with that.
telling us,
Put
and our
on like a little
investigators were telling us. So
biatch.
I believe the flat fee for each attorney would be anything less than the flat fee would be totally confiscatory, Judge. Thank you so much.
Thank you.
I mean,
Ms.
river.
Your Honor, I'm asking for the $15,000 flat fee, and I'm also asking to be
Flat fee.
reimbursed for the $1,800 that I paid to an expert, and JAC has a copy of.
Why are you
my
paying
check
one to the
front and
expert?
back,
I don't even pay money to the expert.
on this case. One of the issues that always has to be addressed when there are multiple attorneys, and I was the 8th attorney and the 4th private court-appointed attorney, is making a case that is old by purposes, for reasons of being on the docket for a long time, a priority, and putting aside other work. One of the unusual things about Ms. Boone's case was when I did withdraw for ethical reasons, the court found that she had forfeited her right to an attorney. She is charged by information with second-degree murder. There was an unusual amount of media attention on this case.
Yeah.
The facts are she's
course it
accused of
was.
putting her boyfriend in a suitcase. He later dies. There is a video of this that went viral. Because the video went viral, because of coverage by Court TV, News
Activity
Nation,
not being taken
Fox, the
seriously.
local channels, the Sentinel, and websites such as Know Your Lawyer, Legal Bites, and Bruce Rivers, you had to review not just the banker boxes of discovery and work done by the previous attorneys, but stay up to date with what potential jurors were viewing if they were watching it on the internet. There was a lot of correspondence between the defendant and the court. Obviously, I had to review all that. The most recent piece of correspondence when I was Ms. Boone's counsel was
you just watch one of my
letter
streams. Got a
that she
summary of
wrote.
it.
And again, all these letters are published, they're analyzed.
Amazing.
I, like previous counsel, spent an inordinate amount of time with Ms. Boone. I spent over 20 hours during my period of time that I was representing her. I believe that for multiple reasons, the court can find that this case was extraordinary and unusual, and that it would be confiscatory to not pay me the flat fee. And having provided the requested proof based on the procedure for reimbursable costs, it's my understanding that Mr. Lake is not objecting to me being reimbursed for the $1,800 that I spent to retain an expert who did not have a contract with JAC.
Yeah.
Thank you, Mr. Lake.
Yes, Your Honor, just briefly. But as far as the issue of the $1,800, JC has no objection to that reimbursement. That's more of a technicality. The court did approve the expert. This is just the attorney getting reimbursed for expense that we have no objection to. So that's a non-issue. So you see that in the order. As far as the fees are concerned, the issue here is that other than Ms. Cashman, who submitted an hourly statement of 118 hours, no other attorneys actually submitted hourly statements, so we are kind of constrained by the statute. The problem is the statute only allows us to 200% of the flat fee in the absence of hourly statements. In other words, the way that the statute is very unusually, but essentially what it says is the court can award up to 200% of the flat fee without, and then we can only go above that if it finds that the case is confiscatory, and then can compensate the attorneys at a rate of $75 an hour. So that's where we get into a little bit of a difficulty here, because double the flat fee here would be $30,000, which is less than each attorney is requesting $15,000 each, would be $45,000. And as far as, and at that point, looking at the statute, what we have is Ms. Cashman, she got 118 hours in. That would represent a rate of $75 an hour, $8,850. Based on Mr. Beckowitz' statement, he had 175 hours in, which would be $13,125 at that rate. And Mr. Hobson, they just basically said about 200 hours, which would be $15,000. That's the issue, Your Honor, is that, I mean, technically compensation has to be $75 an hour for it to go above $30,000. And so beyond that, I mean, ultimately, but you leave the court's discretion to determine reasonable fee for each attorney, and we acknowledge that this, I don't think we can even begin to discuss this is not an extraordinary unusual case. It's just that what the statute says is how the compensation structure is set up. And we have to argue that the court needs to follow that structure.
Mr. Lake, if one bills hourly, can the others be flat fee under your interpretation of the statute?
Until you get to double the flat fee, yes, at work. But once you go above double the flat fee, then at that point, it really should be compensated. You should get $75 an hour. However, we also acknowledge that we have had other cases like this in the court as well, the full flat fee to each attorney, and we've never taken it up. So, I mean, it's essentially, we have to argue that you can only go to 2% of the flat fee, and at that point, it has to go hourly. But we also acknowledge that realistically, there is no attorney on the case. Other than somebody who might take the case pro bono for other reasons, there's no attorney on the surface of this planet that would take this case for $15,000. Your Honor, if I may address.
I don't need to do that, Mr. Hobson. Thank you.
Yes.
I am going to award the $15,000 flat fee to Mr. Bankwitz and Ms. Cashman, and a $15,000 hourly fee to Mr. Hobson. Ms. Cashman will be reimbursed her $1,800 in costs. I will issue an order to that on each of these cases. You've sent me orders electronically, and I will e-sign them. I got it here. And e-file them in just a moment. Mr. Lake, do you have any questions?
No.
All right. Anything further with regard to this matter?
Your Honor, I would just state that I'm not asking for this cost, but I paid over $400 in photocopy fees cost for material that I sent to Ms. Boone along the way. But I I'm not asking for that to be refunded to me.
All right. Thank you, Mr. Hobson.
Let's just broadly start with what is your stance on winner take all, and then why didn't you sign off on possibly?
That was all. That was all that it was. I mean, do I need both options? Do I really? I don't think I do. I don't think I need both options at all. What I'm going to do is I'm going to end the poll in 3, 2, 1, and let's end the poll. See what we got here. Looks like people are wanting the music. I love it. Love it. 3 votes. That's all we got. 3 votes. We'll do some music. If you haven't seen how I make it, then well, you're in for a treat. You're back, cozy, comfy. Got snack, coffee, vanilla bean ice cream, and some caramel, waffles, chocolate syrup, and coconut. Good Lord, that's more than I had. That's more than I had. Let's do this thing, and we'll get some music presented for you. We will make some really cool sounds here. As you can see, they've added some new stuff to this. So we're going to start out with a little bit of instrumentals. What do you think? What do you guys like? Some bagpipes? How about this? Some bagpipes. And I make AI music yourself. Excellent. I'm glad you do. So do I. Let's see. We'll get some bagpipes, some let's see. Some stadium stomping, hand claps, and if I could spell stadium correctly, hand claps and introduction. Introduction in under seconds. There we go. And let's see what happens. We'll just title this one 2. Wonder what bagpipes swing would sound like. Hey, we'll find out. Mm-hmm.
So high with the stars. Up so high, so high, so high.
Oh, I know what happened. That's what happened. Let me move that to trash. Let's see, move that to trash. Trash. All right. So what we got is wonder what bagpipe swing would sound like. All right. Bagpipe swing. Well, we'll get to the swing portion of it. And what I'm going to do is I'm going to copy this. And we are going to hit clear, enter style of music, paste, 2, and create. Let's see what we end up with an intro. Yeah. So you've got covers and stolen valor frauds and channels that you support in music. Awesome. Love it. Love it. Oh yeah. I think I like the first one better. So let's try this again. All right, here we go. So what we're going to do is we're going to extend this thing out from 10 seconds, and we are going to make this going to make this a swing song. Swing. What is that? Jump and jive? Swing, jump and jive. Yeah, that'll work. Jump and jive swing. So what do you want this to be about? Cliffy, but your migraine can't handle that. Oh, you have to try that app out. Oh, that'll be fun. Not too much like a deconstructed drumstick. I've got the hoaxers and stolen valor frauds and candles use. Okay. So what do you guys want to hear? What kind of music do you want to hear? How about? Oh, let's see. Debbie Webb's. Yeah. Write me a song about Debbie Webb's migraine. Write me a song. Giving support to Debbie Webb. Debbie Webb's. What do you say? Webb's migraine. There we go. Write me a song giving support to Debbie Webb's migraine. There we go. Let's see what happens. Try pickle juice for migraine. Migraine days feel so long, pressure pounding head so strong. Close your eyes and bright skies will come. Hang on, Debbie. All right, let's give it a try and see what happens. All right, we're gonna call it Bright Skies for Debbie. And here we go. And boom. You're allergic to pickles? Is it the cucumbers or the pickles themselves? I think it might be the... Bright Skies for Debbie. Let's see what we got.
Migraine days feel so long, pressure pounding.
Migraine days feel so long, pressure pounding head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal through the night. Know we're with you by your side. Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, Debbie, every way. Bright skies will come from the darkened maze. We're cheering you to better days. Gentle whispers ease the pain. Soft tunes wash like the rain. Feel the warmth surround your soul. Healing light makes you whole. Oh, one step at a time. In the rhythm, feel fine. We will conquer this climb. In each little rhyme. Bright skies will come from the gloomy days. Hang on, Debbie, every way. Bright skies will come from the darkened maze. We're cheering you to better days.
Migraine days feel so long, pressure pounding, head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light.
That's good.
Migraine days feel so long, pressure pounding, head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal through the night.
There we go.
Know we're with you by your side. Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, there'll be in every way. Bright skies will come.
I like the first one better.
We're cheering you to better days. Gentle whisper.
My great days feel so long.
Yeah, this one works better.
Pounding, head so strong.
Yeah, I
Close
agree.
your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off
Yeah,
the
that's
light.
good.
Rest and heal through the night. No one with you by your side. Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, Debbie, in every way. Bright skies will come from the darkened days. We're cheering you to better days. Gentle whispers ease the pain. Soft tunes wash like the rain.
All right, let's do the next one.
My brain days for so long. Pressure pounding, head so strong. Close your eyes, the pain will fade.
Let's go ahead, a little bit of
Hold on
Yeah, too.
tight till it's gone away.
get more rock
In the
steady.
dark, turn off the light. Rest and heal through the night. Know we're with you by your side. Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, Debbie, in every way. Bright skies will come from the darkened days. We're cheering you to better days. Gentle whispers ease the pain. Soft tunes wash like the rain. Feel the warmth surround your soul. Healing light makes you whole. One step at a time, in the rhythm feel fine. We will conquer.
Yeah, that's all right. Let's get this one.
My brain days feel so long. Pressure pounding, head so strong. Close your eyes, pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal.
I think we have a
through the
contender
night.
here.
Know we're with you by your side.
Nice shuffle.
Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, Debbie, in every way. Bright skies will come from the darkened maze. We're cheering you to better days. Gentle whispers
All right,
ease
let's
the
try.
pain. Soft tunes wash like the rain. Feel the
One,
warmth surround
two.
your soul. Healing light makes you whole.
The best one.
One step at a time. In the rhythm,
Yeah,
feel
those
fine.
three.
We will conquer this climb.
Four.
In each little rhyme, bright skies will come from the gloomy days.
All right, got a poll in there. That's the one that you want to keep.
Bright
One,
skies
2, or
will come
3.
from the darkened maze. We're cheering you to better days.
One so far. I think one's the best so far. But we'll see what everybody votes on here. All right, so we got choices. 1, 2, and 3. And that one was 3. So you had the first one, which is this one.
Migraine days feel so long. Pressure pounding, head so strong.
Is that right?
Close your
Or is it this one?
Migraine
Oh.
days feel
Oh.
so long. Pressure pounding, head so.
No, it's this one. Right here. This is the one.
Migraine Migraine days feel so long, pressure pounding, head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal through the night.
This is 2.
Migraine days feel so long, pressure pounding, head so strong.
2.
Close your eyes, the pain will fade.
Got a little bit of reggae to it.
Hold on tight.
This one's
till it's
3.
gone. Migraine days feel so long, pressure pounding, head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal through the night. Know we're with you by your side. Through the storm, the pain will hide. Bright skies will come from the blue.
All right, so we got 1, 2, and 3. We're going to get into the poll right about now. And we've got what did it do? What happened? Thought I ended the poll, but it doesn't show anything. Weird. Something happened with it? Something happened with the stream? Went funky? Don't know. Now I'm not seeing the poll there. Let's try it again. Start a poll. Best song? Whatever reason, it didn't show the poll. Song. 1, 2, and 3. Our poll. All right. 1, 2, or 3. See what we got there. See, now it shows up. Damn it. Bastards. All right. 1 got it. Yeah, it wasn't showing up in mine. For whatever reason, it was giving me a hard time. It wasn't showing up. Yeah, we got it right here. It's 1. Sorry about that. All right. So we'll keep 1. And let's see where 1 ends. So if we need to extend it, we can. Oh, that's the whole song. All right. I think that's right.
Guys will come from the dark and maze. We're cheering to better days.
Wrong one.
To better days.
Yeah, that's the whole song. Perfect. Yeah, that's absolutely perfect. So what I can do is I can create and get the whole song. Here we go. Got the whole damn song. Call it Bright Skies for Debbie. Because, man, it is going to be much better than it was before. Copy. Change the name, edit, details. We're going to call this Bright Skies for Debbie. Paste and details. There we go. And we'll close that. So that was the first one. He buffered a bit. Love you, Shizzy. Yeah. Well, curiosity. Buffered a bit. You're a minute behind. It's okay. It's okay. It happens. Mine was acting funky too. So here we go. This is Debbie's song. Bright Skies for Debbie. Everybody, let's hear it.
Migraine days feel so long, pressure pounding, head so strong. Close your eyes,
no, that's
the
wrong.
pain will fade.
Why did it do? It's been acting funky tonight. Here we go. Yes, I did.
Migraine days feel so long, pressure pounding, head so strong. Close your eyes, the pain will fade. Hold on tight till it's gone away. In the dark, turn off the light. Rest and heal through the night. No one with you by your side. Through the storm, the pain will hide. Bright skies will come from the gloomy days. Hang on, Debbie, in every way. Bright skies will come from the darkened days. We're cheering you to better days. Gentle whispers ease the pain. Soft tunes wash like the rain. Feel the warmth surround your soul. Healing light makes you whole. One step at a time, in the rhythm feel fine. We will conquer this climb in each little ride. Bright skies will come from the gloomy days. Hang on, Debbie, in every way. Bright skies will come from the darkened days. We're cheering you to better days.
Nice. That was pretty awesome. This is one that I made earlier today, and I want you. This is the one that was holding me up. So I want to put a poll in there. They don't vote on it yet because you haven't heard it, but I've got 3 of these that I'm going to do, and I want you guys to decide which of the 3 you like. I think these are the 3. Let me double check. Library. Just making sure. Yeah, Dancing on Clouds. I got that one sucked, that one sucked, that one sucked, that one sucked. Okay. Yeah, these are the ones that didn't suck. So imagine the ones that did. All right, so we're gonna listen to 3 songs, and we're gonna start on this one here. That's the best of them. And I think I already created the one that I like, and I just want to get you guys' opinion too, and add an option 3. All right, and let's play the first one, because it is going to be this one here that you're going to hear.
Feeling light, oh so light, in the sky, flying high. Every step, every hop, never stop, never stop. Ooh yeah, ooh yeah. In the clouds, we will sway, night and day, come what may. Floating on, pure delight, shining bright, feeling right. Oh, I'm dancing on clouds, so high, with the stars in the sky. No lie, no lie.
Now we got this one.
Feeling light, oh so light, in the sky, flying high. Every step, every hop, never stop, never stop. Ooh yeah.
In the clouds, we will sway, night and day, come what may.
And we got number 3.
Feeling light, oh so light, in the sky, flying high. Every step, every hop, never stop, never stop. Ooh yeah. In the clouds, we will sway, night and day, come what may.
So, which one do you think got my vote there? So you got a choice between 1, 2, and 3. Which one of those do you think got my vote? 1. Guess you'll just have to wait and see. You favor the blues and bluegrass genre on your music? Oh, don't worry, I've got those too. Got a little bit of everything. Hey, Diane G. And if you guys stick around for another 10 minutes, we'll go over some more of Lynette Preston's deposition. See, this is a way to get rid of a few people that want to come in and give a hard time. So those that didn't, guess what? You get to enjoy the good stuff. This guy here, don't know what I'm voting for, just picked one. All right. I want to give it about 10 seconds. 9, 8, 7, 6, 5, 4, 3, 2, 1, and the poll. And it looks like everyone was thinking between 1 and 2. They weren't really liking 3. Amazing. Because what it ended up being was a full song. And let me see if I can pull it up. Part 1, 2, part 3. And here is the full song.
Feeling light, also light in the sky, flying high. Every step, every hop, never stop, never stop. Ooh yeah. In the clouds, we will sway, night and day, come what may. Floating on, pure delight, shining bright, feeling right. Oh, I'm dancing on clouds so high, with the stars in the sky. No lie, yeah, yeah. Touch the moon, touch the stars. Hearts are free, no more bars. Jumping up, twirling round. Feel the sound, feel the sound. In this bliss, joy rebounds, gravity lost and found. Hand in hand, take the chance, come and dance, come and dance. Oh, I'm dancing on clouds so high, with the stars in the sky. No lie, yeah, yeah. In this bliss, joy rebounds, gravity lost and found. Hand in hand, take the chance, come and dance, come and dance. Oh, I'm dancing on clouds so high, with the stars in the sky. No lie, yeah, yeah. No lie, no lie.
That would be Jorge Torres. It was deleted by Sarah Boone. So that's what you got right there. Jorge Torres. He is the one that was deleted by Sarah Boone. Yeah. So, and he's not messed up. He's just a bad alcoholic. And I think that he was drunk whenever he showed up in jail for this picture. So now that we've gotten some of the music, I needed to lighten up the load a little bit. I'm still debating whether I should. You know what? I need to do that one as its own special stream, because I want to make sure that it keeps in the Florida realm. And tonight, this one was just a little bit shorter because, well, there's not a whole lot going on with Sarah Boone. Well, I mean, there's a lot going on, but it's haven't had the time to watch Sarah's antics. Such a sad case for humanity. Yeah, it is. It is an absolute sad case for humanity. So there is an option here. I think I should give you guys some options, just so you're aware of what we have here. Okay. We've got some killers in Florida that have had a trial just recently. They were They just appeared in front of the court. Their bond hearing was denied. This is a very interesting case. Going to be in court coming up soon, like very soon. About the same time, if I'm not mistaken, we've got about 3 cases, really big cases that are all coming up to cover. Now, this one in particular, it's going to be somewhat short. It's not going to be a very long hearing. And this one is disturbing because it is a Microsoft executive that was deleted by his ex-wife, allegedly, and her husband, her new husband, allegedly, and a hitman, allegedly. It's a hell of a case. It would blow you away seeing some of the information. I've been covering this for a little while. This one is different. This is not going to be Sarah Boone, but I think what I'll do is tomorrow will be a deposition, like the Tetris case. No, this one's a little bit different. Yeah, you've seen some snips of it. Well, yeah, I think that's what I'll do because it's going to be a short one. The one that I have for the deposition, that one's a little bit long, and I don't want to be up too late tonight for this one because I can go long and long-winded. So I think what I'll do is I'll bring this one up first, and we'll just get it out of the way because it's not going to take too terribly long. But they're back in Duval County Court, and it's this one would be necessary, I think, to show. Yeah, this one might do. All right, we'll just share the screen with you guys so you can see it. All right, like I said, a short snippet one. I mean, the whole thing was said 53 minutes. We're already like halfway into it here, and then it ends pretty quick. Yeah.
The form, this court did the analysis on the ground.
Don't give me trouble.
I'm going to deny it, but analysis, obviously
Great.
any discovery issues that
Oh, you little bastard. Why does he give me a hard time?
in the form, this court did the analysis on the grounds raised by the defendant, and also viewing the defendant's motion related to the different areas, the remedies. I've addressed each one of those. So I'm going to deny it, but it's without prejudice because obviously discovery is ongoing, and I don't want the defense to be under the impression that you can't bring this to the court's attention, or if it remains that I would then readdress it. Does that make sense?
It does. And I'm understanding the court's position. So if some new information comes about, we could refile this particular motion, not just asking for limine, but this particular motion is denied without prejudice.
Yes. So I think that the request for a jury instruction, that's not right yet.
That is.
Or I have to
Things like that.
analyze that under a different standard. Additionally, the request and the argument by Mr. Bias at the last court date to release her on bond, I don't believe this is the proper motion or vehicle in order for this court to review that. I've reviewed it based on the papers,
Good.
reviewed it based on the Richardson analysis. And if you believe these things to, just like the rule says, 3.220N, if there are things that remain, and I know the defense has brought several issues to the court's attention. Mr. Bias argued for a really long time, cumulative. At this point, I've analyzed it related to the issues brought to the court's attention. And I don't believe that there's a discovery violation. That's what I found. However, if these things remain, if it continues, I want the defense to understand the court's ruling. You can bring it to my attention again. Okay.
And not to belabor the point, because I didn't ask this specifically, is the defense permitted to refile or renew the request for an argument?
Osmosis.
Yes, you can do whatever you feel as though is appropriate. I've addressed what you brought to my attention is what I'm saying to you. You understand? The discovery violations, there was, in my view, Mr. Bias was arguing the discovery violation / something that was not before the court. Does that make sense? Misleading the court.
I don't agree, but I do understand the court's position.
Okay.
Yes.
So I'm doing it without prejudice.
Thank you, Your Honor.
Uh-huh.
And I believe that the next defense motion then would be motion to compel.
What's the state's position on that?
Is this the motion to compel subpoenas?
Yes.
I'm in agreement with providing discovery if it exists. I've spoken to my detective and am in the process of speaking with ATF. I believe that there was only one subpoena served, the one from Ms. Lucetti, which they're in possession of. At this point, I don't believe there are other subpoenas served, but I don't know that for sure yet. And if I find out otherwise, I will provide those to defense counsel. So I'll fulfill it if I can. If that discovery exists, I will provide it.
So, what's so disturbing about all of this? As I spoke with somebody who knows a little bit about law, I don't. And their explanation of this is they were withholding evidence the same way that they withheld evidence during what's his face, the Pew Pewer in New Mexico. Prosecution withheld evidence that would have changed the line of questioning here. Probably what could have set her free. So this right here, whether she did it or not, the prosecution is not allowed to withhold evidence that could show their client or their person they're prosecuting in a bad light. It would just be like finding out something about, anything that would say, like, this person wasn't here this time of day. They never sent this email. They never sent this message. They didn't do X, Y, or Z. But that's not what happened. Mm-hmm.
When will you know?
I'm supposed to have a call with ATF today. I spoke with Jacksonville Beach Police Department last week.
Okay. All right. So I'll grant that by stipulation. What about the motion for the transcript of Detective John's?
The state's objecting to the motion. I provided counsel with case law and I have some for the court as well. May I approach?
Yes.
What is up? Oh, I thought she was wearing jeans or something.
Your Honor can
Right.
review the cases. They basically state for the long-standing tradition of grand jury proceedings in our country are meant to be accurate to ensure the integrity of the justice system. In both cases, Brookings versus State 495 Southern 2nd 135, which is the Supreme Court of Florida. The court does the analysis, and this is on page 3 of the opinion. There is no pretrial right to inspect grand jury testimony, while holding an in-camera inspection of such testimony is within the discretion of the trial court. The court discusses their decision in Gent, J-E-N-T, which is a cited case, that a mere surmise or speculation regarding possible inconsistencies in testimony is not enough to require the production of grand jury testimony. They discuss the importance of maintaining the secrecy of grand jury proceedings, and that the parties seeking the disclosure must make a strong showing of a particularized need in order to outweigh the public interest in secrecy. The other case the state cited, Bing versus State, 323 Southern 3rd, 830. In this case, the first DCA considered a request to unseal grand jury testimony, but denied it, finding that numerous alleged inconsistencies among state witnesses were an insufficient grounds to grant the motion, where defense is able during cross-examination to direct jury's attention to any purported inconsistencies between the witnesses. And also it analyzes a request to unseal grand jury transcript in order to determine whether the indictment was maintained upon perjured testimony. In this case, the court found that mere allegations of inconsistencies failed to provide a specific basis to conclude that a grand jury witness committed perjury, and the appellant could not seek a blanket production of grand jury transcripts based on mere surmise or speculation regarding possible inconsistencies. And that even when the state's case at trial differs materially from the grand jury indictment, there's no error in the trial court's refusal to dismiss the indictment. Court finds due process is implicated only when a prosecutor permits a defendant to be tried upon an indictment which he or she knows is based on perjured material testimony without informing the court opposing counsel in the grand jury. In order, the defense motion to unseal is merely speculative. It contains surmised allegations. There has been no particularized strong showing by defense that there has been any material perjury or any perjury whatsoever in the grand jury testimony of Detective Johns regarding the indictment. And for the reasons outlined in these cases, the state's going to object.
So, Your Honor, if I may.
Yes.
So in response, Your Honor, I looking at that first case, it's mere speculation that the state is claiming, first and second case, and that is not what we have before the court. We have a specific instance or instances of the lead detective before this particular court making false and misleading statements of material matters to this court.
Ah.
So now we are asking, based on what we know to be false representations of Detective Johns, for his testimony before the grand jury. Because if he's made those false statements to the grand jury, then we are moving forward on an indictment based on perjured testimony. The only way we can verify that, Your Honor, is to actually have the grand jury testimony. But what exactly are these false statements? The court's aware that they received, that the state made a representation to Detective Johns about 3 checks. The checks initiated, or the funds allegedly initiated from the trust of Shanna Gardner. What the state did not argue or present clearly to the court as part of this misrepresentation is that the trust funds that they presented were from 2021. The checks to Tenon were in 2022, but it doesn't stop there. The funds that they showed from 2021, the balance on that very same check resulted in $1,900 and I believe it was about 25 cents. The check to Tenon was for $5,000. So again, clearly the funds that they're showing coming from Shanna Gardner's trust fund weren't related to the check that was provided to Tenon. The theory of the state's case is a murder for hire. The funds that they're showing aren't related. That's material. They also made a representation to the court of a truck that was driven by Tenon, and an allegation that only the individuals involved with the murder for hire would know about this truck. Why is that a problem? Because they failed to demonstrate to the court or show to the court that the roommate, Ordway, was well aware of the connection based on testimony or based on an interview by law enforcement. So these aren't minor or insignificant issues. These are material misrepresentations, whether it's the truck, whether it's the fund, but it doesn't stop there. And again, this is all through Detective John's representations to the court. There's the text messages that Detective Johns was well aware was based on a joke from some 20 years prior. And what did the state present to the court? Text messages, absent the context that this was a very old joke, absent the context that there was a text marked LOL. So to say that this is mere speculation when we can point to verified instances of misrepresentations by Detective Johns before this court, and knowing that he is the main witness, or at least it appears he's the main witness before the grand jury, his testimony has been perjured as we stand here before this court. So that's why we're trying to get through and get the actual testimony before the grand jury. Because if the case should proceed with this perjured testimony, Shanna Gardner's due process rights are in jeopardy. We are trying to have a fair trial and a fair opportunity for Shanna Gardner's case. So this isn't a fishing expedition. We're not asking for every witness that testified before the grand jury. We've narrowed it down to specifically Detective Johns based on his material misrepresentations to this court already. And it's a fair connection to say that he's made similar, or if not greater, misrepresentations to the grand jury. And the only way we're going to know that for sure is to actually get that grand jury testimony of Detective Johns.
Damn, she's good. She is really good. So here's the thing. This guy, don't know who this guy is, this prosecutor right here. He's got some issue. He thinks he's a little bit too tight, too smug coming up here and telling her, oh, X, Y, or Z. Of course, the argument is going to be, well, it's not material. I think that the judge should allow this in. And if this guy has lied to the grand jury, he's lied to the grand jury, he perjures himself, because there's officers that'll do this kind of crap. Not all of them, but there are some that will do this. That this case should not see the light of day. It should get a mistrial. They can retry it again, which I'm sure that they would, which means they would have to bring it before a grand jury again. And they couldn't use the same information. See, that's the problem. They keep leaving things out of this to even bring a case against this person. The three people that are accused of this murder for hire.
So for that reason, Your Honor, and based on all the argument that's before the court in this written motion, we're asking for the court to unseal Detective John's testimony, not for a fishing expedition, but to verify that this indictment that we're all before this court on is actually valid and not based on perjured testimony.
Can I just ask a practical question to the state? Why did you agree on other witnesses and you're not agreeing on this one?
Because I was fulfilling my Brady obligation, knowing that Ms. Jensen had withheld or given inconsistent testimony at another time. I have no such misgivings about Detective John's testimony.
So you're saying to me that you've reviewed the testimony, the grand jury testimony, and these areas that the defense is pointing out, these three areas, there is no Brady in the state's view.
I do not have Detective John's grand jury testimony because it's sealed. I obviously was present for it and have my notes from our pretrial and from the actual presentation of testimony, which was very significantly similar to the sworn affidavit he gave on the Title III wiretap affidavit, which they have possession of. I can't recall specifically these issues. I don't believe there was much discussion of some of these, but I can't say for sure. I haven't reviewed the transcript. But what I would say is they're talking about testimony that came out at a bond hearing regarding the detective's testimony on
No, different.
hearsay. So he's saying what other witnesses have said. We haven't deposed these witnesses. We haven't deposed Detective Johns. They haven't even asked him what he testified to at grand jury, or they haven't even asked him directly about these issues.
There's no point in asking.
Vetted these out through discovery.
No, because what you want to do is what they're trying to do is say, listen, if he gave false representation at this deposition or at this grand jury, they're going to use every single bit of that against him, which means he would be in violation of the law.
So I think at this point, they're saying
They're panicking.
what they perceive to be misrepresentations, which I disagree with. I think that two parties can look at evidence differently, have different theories of a case and different theories of evidence. That's why we have a justice system and trials. They're saying that they believe Detective John's testimony is inconsistent with their theory of the case, and therefore there must be or potentially would be other.
So here's the thing. They had no objection to them finding out what anybody else testified to except for this one person. Whatever it was that he testified to in a grand jury, which is sealed, that right there is the one they're fighting. So it's a possibility without this testimony, it never would have even been brought before this court. Ow. That's bad.
Misrepresentations in his grand jury testimony. That's a speculative statement without any specific substantive or particularized
So let us look.
merit from the state's perspective.
You're on.
I think secondarily, if the court were to be inclined to consider granting the motion, the state would request that Your Honor do an in-camera review of the transcripts before releasing to either side. And if Your Honor perceives there to be anything that needs released, that those particular sections can be released.
I'm going to go back to my original question. So on Jensen, did you have the same information, that is your notes, and you made that analysis and agreed with the defense to
Yes,
release it?
So when Ms. Jensen testified at grand jury, she was reluctant to be truthful. She gave some statements, and then at a secondary meeting at the state attorney's office, she gave additional statements. So I believe that to be information that should have been brought to the attention of defense counsel, which is what I did. I had a phone conversation with Mr. Carodi. I told him that Ms. Jensen continued to withhold and continued to minimize her involvement, in my estimation, and that she had given us additional statements at a meeting subsequent to grand jury that she did not disclose at grand jury. And I believed that that meant, while it was not necessarily Brady because it did not tend to exculpate the defendant, that the fact that a witness gave additional statements that she did not disclose under oath, I believed that they should move to unseal the grand jury testimony. I told them so. It's in the email that Mr. Carodi that we entered at the last hearing. It's in their motion to unseal, and I had no objection. But in this case, their motion has presented nothing to the state that leads me to believe there's anything that they're entitled to receive.
Should be.
This is, Ms. Peoples, do you want to be heard?
Yeah.
I think what I'd like to do is before, I'd like to read these cases, and I would ask that the state look at whatever testimony, make an analysis of what you believe, and I will take it up again. So.
If I may, Your Honor, just
Sure.
a brief point, just making that distinction in the second case, Bing versus State, 323 Southern 3rd, 830. And this particular case ends with because the defense conceded. There is no concession from the defense on this particular case or the material facts that we're arguing in this particular case. So I bring the court's attention to the distinction between the cases brought before the court.
Okay.
Where we have the perjury and we're not conceding to the information that.
Do you have any cases you want me to read?
Other than what's cited in
Okay.
the motion, no, Your Honor.
I'll take this under advisement. I mean, maybe on a review, the state will change its position. If not, then I'll make the ruling. Okay.
Yeah.
But I'm going to take this one under advisement. I've granted the other one. Motion to compel the subpoenas. I'm going to grant that by stipulation. What else is left for today from the party's perspective?
I believe that's all for the Gardner case.
Okay, Mr. Dreiser, do you have any? I have some things I want to cover.
The only update that I have is there was issue about deposing the children at the last court date. We have done that. Those depositions are done. So I just wanted to report that we were able to work all those issues out and get those depositions accomplished.
That's great.
And we have depo dates going back and forth for many different witnesses and different state, civilian, and federal witnesses. And I think we're working through the remainder of the discovery issues. And at this moment, I don't see any court intervention being necessary.
Okay. When are the depot dates?
We were kind of going back and forth on which witnesses this morning, but they're going to get set. There'll be witness.
I know. What are the dates though?
I don't have like the specific dates. We talked about October dates and November dates and December dates and whether we would do the federal witnesses in December. But if you thought that I was saying that I had dates, I just had the concept that we're going to continue depots each month.
Yeah, this stuff intrigues a lot of people.
On the federal witnesses, are they requiring a 2E request?
They are, and I discussed that with Ms. Stippo this morning, and she thinks this particular witness that we would like to depose the state will prepare the 2E letter and get it to him, and it should not be an issue.
All right.
It's the cast agent, Agent Blight, and he testifies for our office all the time. We just email him a 2E letter from our office, and
And I would
it's
be,
very flexible.
if you need this, I'd be certainly, I would email you the depot dates that we select.
I would like those.
Sure.
When do the parties foresee this case being ready for trial?
If I can speed
Discussed
this
that
up a
this
little
morning
bit.
for the first time, like the idea of getting a trial on the calendar was discussed. The only hesitancy that the defense from Mr. Fernandez's perspective has is we don't have all of the discovery ironed out at the moment. There's discovery, I think, that's still being processed through the secondary taint issue from the first issues we've had.
Secondary
It seems
tank.
as if there's some ongoing discovery. I think Ms. Stickler mentioned this morning that she was either about to release new civilian or scene witnesses or just recently did so. I will admit that I wasn't sure which one, but in my mind, the discovery is still sort of ongoing. Setting a trial of this magnitude seems premature, but the state had floated with no discussion with the defense agreeing, but August of next year. And I asked how long they envisioned the trial, and about a month is what I heard, a week of jury selection. I think they were saying probably 2 weeks for their case in chief. And I think they threw in an extra week, not knowing what the defense would call and who we would call. So I think that was a really generalized conversation. I'm not.
All right. We need a trial date.
Yeah.
Okay. I know that you may think that it's premature. I think it's it allows the parties to operate with some type of certainty, and it allows, with a case like this, it allows the court to make proper preparations. Additionally, on the capital side of this case, I know that you all are still working through the issues related to maybe guilt. A couple of things have come to my mind that, like, we need to, if you're going to file whatever capital litigation motions, I want those filed by the end of the year. I want to be able to work through some of those things, know where you all have objections, at least by the end of the year. So, yes, Ms. Peoples.
I would just ask if we could readdress this at the next setting. I know the Gardner team, we've got different schedules or different calendars to deal
Right.
with.
No, I'm
So if you
I'm not meaning to stress you out. Okay. I see the stress on your face. I'm bringing it up because it's never been brought up before. And I like goals. I like deadlines. So
So
I'm putting it out there for you all, and however many lawyers need to get their schedules together. I know with lawyers, especially y'all, I need to book early and often, and that's what I'm going to do.
So
Okay.
could we do that booking, or could we even have the parties present suggested dates or suggested
Yes.
deadlines
And we're not going to go too far in the future either. We're going to go like 2 weeks from now.
for next
Y'all-
month?
Nice.
No, I'm talking like in a couple of weeks. We are going to iron this out.
Dates, okay.
Yes, I want you all to be feverishly that's why I'm putting it out there. Okay, I'm not setting anything today. I'm going to set another court date. All right. So these people do not stress out. Okay. I want the state, okay, to take a realistic look at how you believe this case, how much evidence you're going to put on. I'm going to block y'all off. And it's going to be a while from now. Additionally, I'm putting these things out there. I want to know when you all believe that you can have your capital litigation prepared in order to submit to the court. Okay. I want to know from the state's perspective how long you believe this case needs to be tried. The question in my mind is logistics. Okay. Is there going to be an ask for sequestration? I need y'all to start talking about these things. Okay. And then additionally, when we get the jury selection date, realistically, with the logistics and the number of lawyers, how long y'all believe jury selection will take, if you want to utilize, how many jurors, things like that. I need y'all to start talking about those things. And we are, I know that you all have been focusing on the guilt phase, but we need to start thinking and setting court dates that are going to take up a lot of time, a lot of resources. So I cannot have this kind of just floating out. And we need to start being, we're rounding in my mind, maybe halfway point to, 3/4 of guilt. Mr. Dreiser, you're looking at me funny. I think that y'all can do it. Okay. And then y'all can set your deposit. That date should start informing how many depots, block setting, whatever y'all have to do to try to accomplish these things. Okay. And I need to get some type of gauge on where the defense is with any type of mitigation, if you need any intervention on the court. Okay.
Some information from you that I would request, and some information if I may. I am out from the 4th to the 14th of October. We're going to take that into consideration for the next court date. Not that I have to be here, I guess Mr. Hill and Mr. Gisoni was made to handle it. So I just wanted to let you know that.
No, I'm talking like September 3rd, like next week.
And then, while it may be productive for the state and all of us to discuss these things together to bring, hopefully some consensus to the court. Suppose it was a month, and suppose it was
What was a month?
the whole. Suppose that's an accurate time frame. We all agree. Do you have any insight for us as to at the end of next year when you may have a month? So we're not.
Sorry to hear that.
I'm not booked out that far.
Okay.
And then this is a priority case, obviously. And so I will make whatever arrangements. That's why I need y'all to get together. And this doesn't need to just be something unsaid. So I'm saying it. I want you all to get together, and then I'm going to set, and then we're going to work towards it. And I'm going to give y'all whatever time you need so that we can get to it. Okay. But I'm not booked out when y'all are setting or saying. I'm not booked out that far. So I can give you all the time that you need. And if I will avoid it, I'll avoid the a week or two prior to setting days aside if y'all want me to do that. But we need to start looking at that. Okay. That's what I wanted to bring up.
Yes, Your Honor.
Anything else?
No, Your Honor.
With defense counsel.
Okay. All right. I'll see y'all next week.
Thank you.
What day? I can do Monday. That's exactly a week. Do you want that? Or I can go in a little bit further in a week if y'all want more time. That's fine.
Whatever you guys want.
Wednesday.
I'm sorry.
I'm sorry. I didn't hear.
I'm sorry.
I'm sorry. I didn't hear that you had said one. I know you said next week generic, but
No, next week.
if Ms. Peoples and her folks do Wednesday, kind of better.
No.
No, it's.
Oh, it's not coming up.
Later. Sorry.
Looking at her trial to see what her next available date is.
Should be fine, Your Honor. I can't.
If you need a minute, I can set it when you're ready. Give it, Mr. Dreiser. Give her a second. All right.
So we're looking at October 2nd. Sorry, October 3rd.
September, next week, Miss Peoples.
September 30th.
It's the 30th, the 1st, or the 2nd.
Someone will be here.
Well, I don't want to set something when you all don't have the time. Wednesday?
Yes, Your Honor.
It's no fun.
All right, that's October 2nd. See you all then.
Thank you.
Thank you. 9 a.m. pre-trial. Here are these
There you go.
orders.
Is that going to be in here, of course?
I don't
And
know.
that looks like that is all right there, Steve.
Is 8:30 okay? Are y'all okay with that? I'll set it
Yeah.
at 8:30, Mr. Hathaway.
30 on the 30th. For them to reel this thing in and get it under control. Yeah, they'll be filing motions in the meantime. But yeah, that's really all that it is. So this is an old commercial that used to be out.
Dry, baby.
That's the one that you were asking about. So
Yeah,
that's
no problem.
all that is an old commercial. I think it was like a Palmolive commercial or something like that. So that's all it was. Something about some bubble bath kind of material. This is one of my favorites.
I'm the dude. So that's what you call me, you know, that or his dudeness or duder or, you know, El Duderino if you're not into the whole brevity thing.
Yeah. I'm the dude. Oh, it's beautiful. It's beautiful. Oh my gosh. Is that one? Oh no, I ain't gonna show that. But yeah, that's really all that it is duder. No, I just wanted a nice chill night tonight. Going over the Sarah Boone stuff because tomorrow is going to be some more deposition stuff. Just playing catch up on it or putting catch up on it. One of the two. Probably just playing catch up. I've got a pretty busy week this week with like regular work. I am physically, mentally exhausted just from work. So if I seem a little bit off tonight, that's why. I tried putting some sugar into my system to maybe get me back up and running, but I'm just so out of it right now. So bad. Normally I'm not this bad. I feel off is what I feel. I feel really off. It happens. It happens. You know, you do enough of this stuff. But I love study law. Transcripts would be a problem. I was more into hands-in stuff like welding and building race motors back then. Oh, that's very cool. Yeah. So I've got like I said, tomorrow's definitely gonna be lit than tonight was. Got just work has been keeping me super busy. Like really busy. But right now I'm gonna send you guys over to the wonderful Megan Fox. Go say hi to her. Show her a little bit of love. I'll probably swing by there and listen to her and chat for a while. And no, you never know. She might send me an invite and get my sugar's no good. she might get my excitement up. We'll just have to see. But I'm going to send everybody over to see Megan. Make sure you show her a little bit of love tonight. And that I'm going to have a wonderful evening. I'll see you guys very soon. Until tomorrow, whenever I got some more deposition stuff that I'm going to be showing, I will see you guys. And well, tomorrow morning, see you then.
running through the maze. I felt the pain, chasing my only dream. Break from the scheme. Waking up at dawn, all my fears are gone. I won't stop today, never, never, not today. Compromise, rise above it all, not gonna fall. Step by step I go, faster than the flow. Broke through every chain, I will not be contained.